Honorable Hendricks, welcome you to the Portfolio Committee, and thanks very much for having considered to present the private members bill and the team that has assisted you to introduce this private members bill, and the Minister of Home Affairs for also having considered to, and his team, to brief the committee on the process undertaken at the level of the department, and members will then raise question, will then deal with the matter of taking a decision on this matter once we've get a sense of what are the issues that members are raising, and both yourself and the Minister of Home Affairs are raising. It's your time now, Honorable Hendricks. You're invited to brief the Portfolio Committee. Thank you very much.
Good morning, Molweni. Assalamu alaikum wa rahmatullahi wa barakatuh. Mr. Chairman, Honorable Sabani of the Portfolio Committee of Home Affairs. I'm indeed honored that the Minister of Home Affairs and the Director General of Home Affairs is present. It shows their commitment to be present whenever they can, when important issues of any community in South Africa is raised. Thank you for granting me an opportunity to further brief you to assist this committee to consider a motion of desirability for my private members bill called the Registration of Muslim Marriages Bill.
Recording in progress.
I hope my briefing that I sent honorable members on Friday and I sent to the department on Friday will persuade honorable members to support my private members bill. I know that I am contesting and support for this bill with the Department of Home Affairs and the Minister and the Director General, which will try and persuade honorable members later this morning not to support my private members bill. So this is an interesting contest, and we hope that we will be able to persuade one another to come to an amenable solution. Honorable Chair, the Constitutional Court had to step in to address the state's failure to deal acceptably and lawfully and constitutionally with Muslim marriages. So when the Concord found fault with the Marriage Act and the Divorce Act due to their failure to meet the constitutional principles of dignity and equality, because it failed to recognize Sharia marriages as valid marriages, I crafted a bill to comply with the Constitutional Court judgment, meeting its deadlines to save the executive and parliament, which includes myself, not to be delinquent and in contempt of court. I'm aware of the fact that the Department of Home Affairs promises to have a bill that will address the orders of the Concord with regard to the recognition of Sharia marriages ready by June, postponing the date promised by the Green and White Paper by a year, and later postponing it again from March to June this year, letting down the stakeholders it consulted like the MJC by another 3 months. In their heart of hearts, Honorable Chair, the Department of Home Affairs, the legislative drafting team of Parliament, the Parliament Constitutional Master Committee, the legal head of Parliament, know that the Department of Home Affairs will not be able to meet the deadline of a Concord. That is 12 months from now. They know that. For as long as the so-called Omnibus Marriage Bill is not promulgated, and my guess is that it will only happen in the 7th Parliament, I may not even be elected to the 7th Parliament. There remained a need to regulate the recognition and registration of Muslim marriages in South Africa. The point being, Mr. Chairman, the point being made that this Omnibus Marriage Bill was put in motion too late. Even the Cabinet rejected the latest version. And if the interim registration of Muslim Marriage Bill 222 is not adopted, then there will be a lengthy period where no legislation regulates the essential aspects of all Muslim families in South Africa. The Department of Home Affairs will therefore be in contempt of court, and Parliament would have failed in its oversight role if it does not utilize other interim measures that have already been set in motion and could easily be supported by the department to both comply with the Concord Order and comply with the constitutional obligation of avoiding one more day of infringing the constitutional rights of all Muslim women and men married in terms of Islamic law or intend to get married in terms of Islamic law during the interim period. On the 6th of January, the Director General, and he is present here, of the Department of Home Affairs, the respected Mr. L.T. Makodi, issued a circular introducing his staff, especially at the front desk of Home Affairs officers, to register all Muslim marriages in terms of the Recognition of Customary Marriages Act 1998. It must be further noted that the Recognition of Customary Marriage Act in its entirety cannot be applied to Muslim marriages in any manner that will be considered constitutionally and legally defensible or sound. This is because customary law is specifically defined in the Recognition of Marriages Act as the customs and usages traditionally observed among the indigenous African people of South Africa and which form part of the culture of those peoples. While this definition may include many indigenous African people that are also Muslim, and for generations we know since the founder of Islam in South Africa came to Makassar 350 years ago in Cape Town, there were already African indigenous people embracing Islam. It would not provide for the specific application of Sharia law to such marriages at all. And in fact, it would create a conflict of laws. One merely has to consider how vastly different the concept of Labola is to the mahar, the Islamic dowry. Then one can appreciate how in practice this can create problems for the prospective wife within the family and may open up risk factors for practice like orchestrated kutwala, domestic violence or abandonment. This is an untenable situation, Honorable Chair. The Act patently would not be applicable to and exclude those Muslims who are not indigent African people. So let me come back, Honorable Chair, to the circular. The circular is an incorrect interpretation of the court judgment. So the Director General took it upon himself to register Muslim marriages in accordance with indigenous African customary law. As regards Clause 6 of my private member's bill, the Minister is empowered to promulgate regulations whereby he could vary the time period with which the registration of Muslim marriages should be varied. So any concern of the Minister can be resolved in accordance with that clause. There is nothing wrong with my Clause 6. I submit as I received a certificate of compliance by Parliament's Constitutional Certification Committee. The Minister can hardly raise the point in question as a reason for not being in support of my interim bill offered to him that would avoid him being held in contempt of court, especially because this is a, in inverted commas, get out of jail free card. Jama-ah has been working not only with the sole Muslim body, the MJC, the Minister and his department consultant, but working with 200 Muslim African wives. Other Muslims from Zandvlei, where the first settlement of Islam started 350 years ago. Each of the other 30 ulama bodies in South Africa, which the department did not consult unless that's not on the record, Muslim lawyers and the youth who will face the brunt of any further indignity. African ulama in their numbers were consulted. And all this can be seen in our memorandum, which is published in the Government Gazette. The bare bones bill I submitted contain only the essential aspects of registering a Muslim marriage and the consequence of entering into a Muslim marriage. Coming to the bill, in summary, the bill makes provision for the recognition of Muslim marriages, the requirements for the conclusion of a valid Muslim marriage, the solemnization of Muslim marriages, the registration of Muslim marriages, the propriety and other consequences of Muslim marriages, the dissolution and consequences of Muslim marriages, and the automatic repeal of promulgation of any final legislation by Parliament which addresses the failures identified by the courts. The bill is intended to regulate, like I said, the recognition, the requirement, solemnization, the registration, propriety, and other consequences, the solution and consequences of the solution of Muslim marriages, and to provide for matters connected therewith. As I speak, Muslim wives do not have access to the divorce court. All other women in South Africa have access, and that is unacceptable. Section 1 provides for definitions of key terms and concepts unique to Muslim marriages, the required procedures, and the role players in the solemnization thereof. A key term is the definition of Islamic Sharia law, which a constitutional court has raised. It has said that Sharia marriages are valid South African marriages. So we need to know what the definition is. I'm not sure whether the minister in his omnibus bill has defined the definition of Sharia, which means the law is derived from traditional customs. In Arabic, it's called al-urf, the two primary sources, the Quran and Sunnah, and then also qiyas and ijma. Muslim marriages subject to Section 2 is a legal contract of marriage that regulates the consequences of parties' intended marital relationship, concluding to a ceremony referred to as a nikah in accordance with Islamic law. Section 2, and I'm now on page 9, those of who's following the briefing. Section 2 provides for the application of the bill to a Muslim marriage concluded after commencement. The bill will also apply to a Muslim marriage concluded before commencement if the parties to that Muslim marriage elect to have their marriage so registered with the department. Clause 3 provides for the recognition of Muslim marriages as valid in law. Clause 4 provides the requirements that the parties must comply with in order to conclude a valid Muslim marriage under the bill. Party must comply with Islamic rulings regarding required age as well as the prescripts already set out in Section 22 to 27 of the Marriage Act. This clause therefore accords with the current statutory marriage regime and accords with international and regional human rights treaties and declarations such as the SADC Protocol on Gender Development which South Africa signed. Such treaties provide that one, no person under 18 may marry. There may be other exceptions, specifications in the law provided that take account of the best interest of the child. Other requirements under this clause include that the parties must be of sound mind. They must not be aware of any lawful impediment to their proposed marriage. The marriage must be freely and voluntarily entered to, and consent to be married to each other must be provided in writing. This is all to avoid human trafficking in terms of South Africa's commitment when it comes to international agreements. Clause 4 2 provides that the prospective wife must determine the dowry that she expects from her prospective husband. We call that the mahar. It's completely different to the lobola. The dowry may include the performance of any obligation prior after the marriage has been performed. This gives the Muslim wife more rights than any other woman in the world. The acceptance of requested dowry by the prospective husband creates a binding obligation on that prospective husband, which will never prescribe. Clause 4.3 provides that the parties may each mandate a person to negotiate the dowry on behalf of the parties to the marriage. And we all know about Temba, how he negotiates in Movambu. Clause 4.4 provides that the agreed terms of the dowry must be recorded in writing and noted with a marriage certificate issued by the marriage officer. This provision has no equivalent in civil law and is meant to provide a measure of financial security to women in Muslim marriages. The passage of this bill would permit the enforceability of this Sharia law right, which cannot be enforced at the moment. Muslim wives cannot even have access to the divorce court because they don't have a valid South African marriage certificate, although they have a nikah certificate. Clause 5.1 provides for the solemnization of Muslim marriages by a marriage officer. It provides that a marriage must be conducted in the presence of the parties to the Muslim marriage themselves and in the presence of at least two competent witnesses. Clause 5.4 provides a marriage formula and in accordance with Islamic law tenets. Clause 6 provides for the process of registration and the responsibilities of the marriage officers, which will be at the front desk of the officers of Home Affairs. In this process, such responsibilities include to complete a certificate on the prescribed form, state at the time of solemnization of the marriage he was entitled to solemnize the marriage, record the details of the parties to the Muslim marriage, the date, time, and place, note the terms of the dowry as contemplated in Clause 4.4, which is completely different to the lobola. indicate the matrimonial regime contemplated, selected by the parties within a reasonable period after the conclusion of Muslim marriage, transmit the marriage register certificate in any prescribed documents to an authorized officer contemplated in the Identification Act, and keep record of the marriage, including a copy of the certificate contemplated in subclause 2, until such time that the Muslim marriage is duly registered with the department. Clause 6.4 allows for the retrospective effect of the right to have Muslim marriages registered in accordance therewith and application by either spouse to a Muslim marriage. Clause 6.5 permits either party to a Muslim marriage to request a marriage certificate. Clause 6 provides that marriage certificate is prima facie proof that a valid marriage exists between the spouses and it has been registered with the department. The above provides critical relief to a Muslim spouse who seeks the legal vindication of any of the rights which arise from the marriage, which have to date been unobtainable. There have been many disputes in our courts when there are more than one Muslim wife. Who is the wife? And this has caused a lot of hardship, and this needs to be addressed. Clause 7 of the bill is of the utmost importance. It provides for the propriety consensus of Muslim marriages as follows. The parties to a Muslim marriage must voluntarily choose the matrimonial property system that will apply to their marriage. That is required in terms of other acts. The election must be indicated on the Home Affairs prescribed form. Now, here I want to thank the Minister of Home Affairs. I know he's going to fight with me later on when he tries to tell this committee that this bill must be rejected. But Mr. Minister, this is a creative innovation proposed by you to reduce legal costs and notarial deed costs for indigent couples, nearly 5,000 to 10,000 rand for all of this. And most Muslim couples that have got married can hardly afford a decent ceremony and celebration, and they are indigent. And so 80% of Muslims in the Nikah in South Africa don't have a marriage contract, don't have a notarial deed because they can't afford it. A court may an application by, if the chosen matrimonial property regime is that out of community of property, without accrual, an anti-nuptial contract must normally be entered into and must comply with Chapter 7 of the Deeds and Registers Act. The minister's innovation does away with this, and minister Muslim wives and even the groom will thank you for that, because now there will be a contract and it will comply with the Deeds Act. A court by an application by either or both of the parties to the Buddhist marriage subject to such conditions as may desirable authorize the post-nuptial execution of a notarial contract having the effect of an anti-nuptial contract if the terms therefore were agreed upon between the intended spouses before the Muslim marriage, and may order the registration within a specified period of any contract so executed in accordance with Section 88 of the Deeds and Registers Act, provides for the applicability of the Matrimonial Act 1984 to the matrimonial property regime chosen by the parties. And here I must thank the Parliament's legal advisor, the Constitutional Master Committee, the drafting team for their valuable assistance to ensure a bill that South Africa and the nation can be proud of and they can comply with the requirements of the Concord. Clause 8 of the bill, similarly of great importance, provides for the equal status and equal capacity of spouses, stating that each party to a Muslim marriage has full status and capacity, including the capacity to acquire assets and dispose of them, and to enter into contracts and to litigate in their own name. This is in the bill. Clause 9 of the Act deals with the dissolution of Muslim marriages to safeguard the interests of minor children and dependent children born of a Muslim marriage, provides that the court must consider the Mediation in Certain Divorce Matters Act 1987, Act 24 of 1987, and the Children's Act 2055, Act number 38 of 2005, in addition to such provisions in the Divorce Act. The bill provides that the court granting a decree for the deletion of a Muslim marriage may, in addition to any order provided for any relevant statute, order that any person who, in the court's opinion, has sufficient interest in a matter be joined in the proceedings, and when making an order for payment of maintenance, take into account any provision or arrangement made in accordance with any contract concluded between the parties and the prevailing Islamic rulings at the time. But Muslim wives can't go to the divorce court. They're barred from going to the divorce court because they don't have a valid South African marriage certificate. And there's 12 months to go, Honorable Chair. And the Department of Home Affairs and the Department of Justice have done nothing to comply with the order of the Constitutional Court to amend the Divorce Act, and Jama-ah did it, and that will still come before the Justice Committee. And it's only 4 minor changes, and both departments have ignored it. They are going to be contempt of court. Parliament will be accused of not doing proper oversight. Even the 2 committees will be accused of not doing proper oversight, because nothing, absolutely nothing has been done so far. Nothing is before anyone amending the Divorce Act. Nothing in this section should be construed as limiting the role recognized in Islamic rulings of any person, including any established Muslim judicial body, in the mediation in accordance with Islamic rulings or any dispute. The Green Paper said that there should be an alternative dispute resolution to deal with disputes, not to clog the courts. So we already have in the Muslim community hundreds of alternative dispute resolution bodies, which this bill will now give more powers to and more teeth. So the Muslim community is ready to implement the suggestion in the Green Paper that different communities must have alternative dispute resolution procedures, like, for example, the CCMA when it comes to labor matters. And I've got 40 years of experience in the CCMA. So similarly, other people have even more and better experience. So Clause 10 empowers the cabinet member responsible for the administration of home affairs to make regulations on various matters required under the bill. I referred to that earlier on. Clause 11 provides for the limited duration of the application of the bill. Clause 11.1 provides for the abrogation thereof, stating its limit duration as follows. This act, my private member's bill, is automatically repealed upon the commencement of an act of parliament. And that act, I said, will be in the 7th parliament. I may not even be a member of parliament then. So when that bill eventually sees the light of day, and we've seen over the years how the marriage bills, the previous marriage bills we President Zuma threw in the waste paper basket, went through all courts in the land, from the magistrate court to the high court to the appeal court, and eventually the Constitutional Court has now settled the matter. But for 15 years, Muslim wives have to suffer the indignity. And an Honorable Chair, do you want them to suffer another day? They can't go to the divorce court. Their dignity is harmed. And I've just read an article by a professor at Potchefstroom University and another university that wives are still regarded in terms of our laws as wars. That is unacceptable. My mother had 2 safe houses, and that's what she fought for. Imam Harun died in detention. He was bludgeoned with a 10-pound hammer, and because of the Marriage Act, which the Constitutional Court declared unconstitutional, his 12-year-old children and younger daughters were left homeless because of this Marriage Act. And that's why not a day longer, Honorable Chair, must pass. And any suggestion by the department that we must delay my private member's bill must be rejected. In the briefing I sent to the Department of Labor and also to honorable members, in fact, 84 people received it. We suggested a compromise that the circular that the Director General erroneously sent out and deciding that for Muslims, he's a mufti, he decides that in terms of Sharia that the Custody Act must apply to Muslim marriages as if the department knows how the Sharia works. They should have consulted more widely and not just make such a blanket ruling and impose an act on us which goes against our religion. It goes against the judgment of the Constitutional Court. It goes against the judgment of the imams and the maulanas. Lastly, Honorable Chair, Clause 12 provides for the short title and commencement of the Act, stating that this Act is called the Registration of Muslim Marriages Act 222 and comes into operation on the date fixed by the President by proclamation in the Gazette. Honorable Chair, concluding, I know that this committee is solutions orientated. The chairman of this committee, in fact, arranged a meeting between me and the minister in order to find solutions. That, I must put on record, is appreciated. That is real leadership. But that leadership extends to members of this committee, and I'm not patronizing. This committee must but understand now the position of my private members' bill. They will later hear what the position of the department is. I hope they're going to change their position after they've listened to this, so that we know that they do listen, because the minister's here and the director general is here, and we are not here to point any fingers. These are difficult matters, but Jama-ah has provided, Honorable Chair, a mechanism. The outcome we want of this briefing, Honorable Chair, is for the establishment of a mechanism for the registration of Muslim marriages or the front desk at any office of the Department of Home Affairs until such time as the omnibus bus sees the light of day, and we wish the minister every success. The minister have even indicated, Honorable Hendricks, withdraw your bill and we'll put your bill in the omnibus bill. But Minister, I can't allow Muslim wives to suffer one more day and not to have an opportunity to take their issues to the divorce court, which is a free court. You don't need lawyers and advocates to address their many problems. There are at least 100 cases of Muslim women who are assisted by NGOs going to the courts because they seek redress as a result of the breakdown of their marriages. I thank you, Honorable Chair, and I thank the members. And I tell the members I'm looking for a solution-based debate and moving forward. Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Thank you very much, Honorable Hendricks. Well appreciated, and your team for taking time to brief the committee. We have been dealing with various issues in the portfolio committee, and members of the committee are detailed on processing issues. Thank you very much, Honorable Hendricks. Well appreciated, and your team for taking time to brief the committee. We have been dealing with various issues in the portfolio committee, and members of the committee are detailed on processing issues, whether private members' bill or any other matter that comes before the portfolio committee. So rest assured that in our interaction with both yourselves and the minister, members of the committee, in their wisdom, will able to process this matter, looking on the issues that resides or in the spirit of the Supreme Court of Appeal or the Constitutional Court judgment. We will then come back again to you when members are commenting on Hendricks. Stay with us. We'll give the minister an opportunity also to present. Then members after will comment, and Honorable Hendricks and the minister and the team will respond to the comments from members of the committee. Minister?
Thank you very much, Chairperson. Thank you, Honorable Hendricks. Chairperson, I want to put it up front that we are not here to compete with Honorable Hendricks. We are not at variance with him. We are not his enemies or his opponents in this matter of marriages. We just want to find solutions, as we are saying, Chairperson, because we are all South Africans, and we want all South Africans to be comfortable. The presentation I'm going to make is not to prove Honorable Hendricks wrong. It's just to put the facts on the table so that members of the committee can exercise their own discretion on what to go on how to go on, taking into consideration that both bills, the private members' bill and the executive members' bill, will still have to be processed by the very same committee. There's no question about that. There's no other way of doing it. Now, it is true that we did meet Mr. Hendricks, myself, and the chairperson of the portfolio committee. It is true that we're trying to look for solutions. It is true that we never reached any final or tangible conclusion. And I'm sure today, after you got this presentation and you got mine, the committee might like to go and consider all the issues and come out with a probable solution. You may remember, Chair, that this whole issue of marriage in South Africa is a sore point for all religions, for all traditional groups, for all rights groups, for many NGOs, etc., etc. It is for this reason, Chair, that in August 2019, when we started the first meeting of consultation on these issues, we're inviting, scholars, academics, traditional leaders in various communities, including the Kon and Sai, the various religious groups, Christian, Muslims, Jews, etc. We're all consulting them. And I can tell you, it was not an easy exercise at all. Because, Chair, marriage is not just a legal document or a legal undertaking. Most marriages reflect the culture of individuals. It reflects their spiritual understanding. It reflects their religious beliefs. It reflects their philosophy in life. In some cases, it may even reflect their political orientation. That's what marriage is all about. And for that reason, it's a very, very complex issue. We are just coming in to, as the government or as the law, to try and give a piece of paper such that nobody can deviate. But the agreement between two people has already been made. If you check all the rulings of the court on this issue, they don't put very serious emphasis on the fact of having a legal paper for marriage. They follow exactly what was the intention of the two people, what have they been doing. And maybe during the course of this discussion, I may have to quote that. Now, in the final analysis, after all this consultation, remember it took 4 years. We wanted to develop a white paper. When we went to the cabinet, they said, no, this matter affects each and every sector of the community in such a profound way. We want you to go back and start with a green paper so that everybody's proposals are considered in the green paper. You may remember, honorable members, how in that process, we also put in the issue of polyandry, which raised lots and lots of firestorms, even by members of this committee, even by cabinet. But we're just trying to accommodate everybody's proposal so that they get discussed. And that's how far back we started, with a green paper, and went through all those firestorms. And in the final analysis, we said we must produce an omnibus bill which will accommodate all South Africans, which finally will be characterized by 3 things: characterized by human dignity, by equality, and non-discrimination. And that is what this committee is faced with: how to produce a final act that reflects all these 3 characteristics: human dignity, equality, and non-discrimination. Let me maybe try to clarify, not again to compete with Honorable Hendricks about this issue. Cabinet never rejected the present draft in the bill. It was going through the motions of cabinet. And in the last meeting, there are several issues that were raised by the Department of Justice, and Cabinet sent us back because they don't just want to be rubber stamps. They sent us back to deal with those issues so that when the bill finally ends up in public, the issues are resolved from government itself. And so that's exactly what happened, and we believe we are ready now to put it forward. The issues of the Constitutional Court, we are also dealing with them. I'll show them during the presentation. Chair, let me then start presenting, because some of the questions or issues raised by Minister Hendricks are already in my presentation. Well, that is just an introduction about Mr. Hendricks, what he has presented. We've already gone through that. Can we pass? Yes. Chair, it is important to note, and I'm emphasizing again before going through clause by clause, that we are not in this to compete with Mr. Hendricks. We are here together in a common journey to find solution of a very, very serious and a difficult problem when dealing with society. Now, it is important to know that clause 11 of the private members bill deals with limited duration of application of the act. In part, it says this act will be automatically repealed upon the commencement of the Act of Parliament regulating the registration, recognition, solemnization, proprietary consequences and dissolution, and consequence of dissolution of Muslim marriages. In other words, the private members bill is saying as soon as Parliament has finalized with the executive members bill, the private members bill will automatically lapse. But in our thinking, unless corrected otherwise, we think this committee is going to have to deal with this present, if the committee accepts, of course, that they need to do it that way, they are going to deal with bills, two bills in parallel simultaneously. And after passing them, one immediately lapses because the other will also have been passed.